I'm Daniel Clockfelter, and I have my sidekick, Bonnie Lilac, who is pushing the buttons today. That's what she likes to do.
Good morning.
And good morning. And I just want to tell people, because there's going to be people that watch this in a recording, and I want to share how this comes about, like how we came about on our strategy partners calls. And usually they're closed, but we're going to put this out, and we invited some other people to it for new faces. But it comes from my personal belief that we all do better once we know better. And we really can't do better until we've been introduced and exposed to something to do better. So if I share a system with you that's better, you're most likely to implement that system. And what I want to do is give access to experts that I talk to, all the way across the board, professional, everything from attorneys to CPAs to anything that, roofers, anything that we need in our business, and we all need, like these wills and estates. This is super important for everybody. And talking about an expert that we've got access to today, and there's going to be 2 more videos. There'll be 2 more weeks, 3 weeks in total. So we'll get through as much as we can get through. But Andy Hartman is here.
When we can answer these 2 questions, we can set a course of action to get to closing, because even at this point, we don't always have to probate to move ahead. Okay? But let's touch on tenants in common real quick first, okay? So let's say in our scenario with Mickey and Minnie that they held as tenants in common for the language of their deed. And like I said, if joint tenancy is not in the deed, then it is presumed to be tenants in common under Georgia law. It does not have to say the words tenants in common, okay? So here we are back to our deed. And on the second line there, after Mickey and Minnie Mouse's name, there is just nothing. There's no joint tenants with survivorship, and it does not say tenants in common. And in that case, this is a tenants in common deed, okay? So if they own as tenants in common, Minnie's gonna have a few more hoops to jump through to sell or transfer the property upon Mickey's death, okay? And those things depend on, again, whether Mickey had a last will and testament or he died without a will, and how long ago did he die, and how cooperative are the heirs, which could be Minnie's children, could be some of Minnie's children, some of Mickey's children, if they are a blended family. Those things become very important in how we proceed, okay? Do we always need to probate? As I mentioned, no, we don't always have to probate, even if they hold as tenants in common, okay? Probate can be avoided if we have a few key facts and circumstances in our favor. If the deceased did not have a will, that's key, and the death was more than 3 years ago, and all heirs are 18 or older and of sound mind. We don't have anybody that is under a conservatorship or, for one reason or another, cannot speak for themselves. And the heirs have to be pretty crystal clean when it comes to having liens against them, or we may find ourselves having to pay off liens of heirs at the closing. All right? If all of those 4 conditions are met, we'll again make a copy and record the death certificate. We're going to record what we call an affidavit of descent, which is something that we prepare as closing attorneys, or if they have a family attorney, we will allow them to do it if they follow the format we need. Has to be witnessed and notarized, signed by at least one of the heirs. Okay? We can also get an affidavit of descent signed by at least one disinterested party who has actual knowledge of the family and the heirs over a long period of time. Typically, we're going to require that this person knew the family for at least 20 years. Yeah.
So what technically is heirs? So is it just direct descendants, or is it grandchildren? What is it?
Yes, good question. Georgia, as in every state, Georgia has a code section which lists the descendancy laws in the state of Georgia. So yes, your heirs are your children, and if one of your children have deceased, then it is the grandchildren of that child. Okay. If the person dies without children, we look, again, let's presume you had somebody that not only just never had children, okay, so they're obviously not going to have any grandchildren. You then look to the parents of the deceased person, and they become the next natural heirs. And if the parents of the deceased person have passed, then you spread out to the side and you look to see whether or not the deceased had any siblings. And then you start fanning out the net. All right, no siblings, let's go to first cousins. Let's go to aunts and uncles, and that's the procedure by which you decide who the heirs are. So then we get a quitclaim deed in that all of the heirs must sign. So what we're doing in this case, in order to have the privilege of avoiding probate, we have, again, first the person had to have died without a will and more than 3 years ago, or we're not even to this discussion. But if those 2 things have been met, this is where the cooperation of the heirs becomes so important, because we're going to need all of them to basically sign a quitclaim deed that's going to release their interest in the property, and they're essentially going to have to be agreeing that all of the proceeds from the sale of the property are going to go to one or two particular individuals, depending upon how who your seller ends up being. Okay, and you know, if you got one holdout, if you got one stepdaughter 3 states away who hasn't spoken to the deceased in 15 years, that doesn't mean they're not an heir anymore. And we have had situations where we'll call him the grumbling stepchild from the first marriage who disowned dad, you know, 15 years ago and never spoke to him, never came to see him when he was sick. They still can hem up a closing and kind of ask for a check in order, you know, as a condition of signing the deed. It does happen.
This is where we find out how many half brothers and sisters you have.
Yeah, you'll always find out. If we have a situation where the person has died less than 3 years ago, which is more often the case, you have to move to probate. There's just not another way around that, other than something that we call year support, which we will get into briefly. Some of you may have seen that.
I'll be sharing insightful and informative videos on stress-free retirement, being your own bank, setting up college funds, understanding Social Security, wills, probate, trust, and how the Fed Reserve rate hikes affect your mortgage rates. And always real estate solutions. I'm your go-to expert in real property. Look for my YouTube channel, living in Canton, Georgia, where it is sunny as can be right now. If you find value here, please like and share so others might as well. Remember, I'm not a videographer, not a video editor. I just want to share the most important info with you guys. Each video has a full version of around half hour or so, but there are multiple shorts of only 5 minutes or less as well. My name, Daniel Klopfelter. My area of specialty is real estate and asset protection for more than 25 years. So why am I exhorting you to view financial-based videos on a real estate channel? Good question. I believe that we all do better when we know better, which is why I'm here to expose you to a team of experts who know the topics that matter most. All of these topics work in unison. Full disclosure, I receive nothing for doing these videos other than the satisfaction of adding value to you. So smash that like button already. What are you waiting for? Share this so other people can see it. Y'all have a great day.